Okay, so chapter 5 of your textbook concerns the struggle for civil rights, although your textbook calls it equal rights. So, what are civil rights? The term civil rights refers to the freedom to participate in the full life of the community. That includes voting. It also includes the use of public facilities and services. Now, keep in mind, in my classroom, when I use the term public, I am referring to anything that is funded by taxpayers. So the primary and secondary schools, the police department, public safety, fire department, all of those are public goods or public services or public facilities. And so civil rights also encompasses the ability to use those facilities and services. It also refers to equal economic opportunity. That means the ability to start a business. It also means the ability to engage in commerce and buy things and go shopping and so forth. More broadly, civil rights refers to freedom from discrimination. So, what is discrimination? When we think of discrimination, a good definition to use is less than equal treatment based on a classification. So, what is a classification? Race, ethnicity, gender. Typically, these are things that you are born with that you can't really change in your life. You don't really have a choice over that. So de jure discrimination is established by law. De jure discrimination refers to a circumstance where the authorities have passed a law that prohibits some activity for one race or ethnicity or gender without any rational basis for doing so. There's also de facto discrimination, which is more subtle and informal. Now, if you recall from chapter 4 on civil liberties, we have freedom of conscience in this country. A person is free to possess racist beliefs or sexist beliefs. The issue is whether they act on them. Specifically for this course, the issue is whether they use state authority to enforce those beliefs. So I'm going to do just a little bit of history. In 1865, the Civil War came to an end. The United States enacted 3 amendments to the Constitution, the 13th, which outlawed slavery, the 14th, which guaranteed due process and the equal protection of the laws to all citizens regardless of state, and the 15th, which granted African American males the right to vote. In the presidential election of 1876, the Republicans struck a bargain to hang on to the White House. They agreed to remove federal troops from the South. Those federal troops had been protecting the polling places so that African Americans could vote. And actually, it was in the period from 1865 to 1877 that the first African American members of Congress were elected. After 1876, beginning in 1877, the southern states began to pass what became known as Jim Crow laws. Jim Crow was a character from a minstrel play. This is a character typically played by a white actor using shoe polish to appear black. And so the literacy test was one law. They would selectively require a literacy test for African Americans who tried to vote. I should point out that the reason this was effective is because many states had laws that prohibited slaveholders from teaching their slaves how to read. And so many of the freed African Americans were illiterate. In fact, probably the majority of them were. There was open employment discrimination, and there was open discrimination in lodgings and accommodations. In fact, up until the 1960s, it was very common to talk about a restricted hotel. A restricted hotel was one where African Americans and oftentimes Jews could not stay. So this continued. The Jim Crow laws were challenged in federal court. The most important case for our purposes is Plessy versus Ferguson, which was handed down by the Supreme Court of the United States in 1896. What happened there was an African American purchased a train ticket, and he paid full price for the train ticket. He paid the same price that a white man would have paid for the train ticket. However, he was forced to ride in a segregated car. A segregated train car, that is. Or compartment, if you want to call it that. So he sued in federal court, and the Supreme Court ruled that separate but equal facilities were allowed. And this became the legal underpinning for both private and public segregation. The reality was that separate facilities for African Americans were almost always inferior. So this photograph is from Clarendon County, South Carolina, during the 1949 to 1950 school year. Historians have gone back and looked at how much money was spent at the whites-only schools and at the segregated schools, and you divide that by the number of students and the number of teachers, and you can figure out that black teachers made 2/3 what their white counterparts made, and the county spent $43 per black child versus $179 per white child. So that means that the county was spending at least 4 times as much on white children as they were on African American children. Now that little schoolhouse actually contained 2 classes. So you see all of those children would have been crammed into that one little schoolhouse. When we talk about civil rights, we're going to concentrate on the post-World War II civil rights movement in the United States. It was after World War II that the civil rights movement really picked up steam. There were a large number of African Americans who served in World War II, oftentimes with distinction, and of course World War II was sort of touted as a fight for democracy. And so they found themselves in a position where they had gone to Europe to fight for democracy for Europeans, but then came back home to the United States and faced discrimination. There was a growth of organizations combating segregation. There were new venues and tactics used besides the ballot box. Lawsuits, for example, were successfully used to desegregate some professional and graduate schools. One of the key lawsuits concerned primary and secondary schools, that is elementary, middle school, and high school. There were a number of plaintiffs who sued several school districts to allow their African American children to attend the same school as the white children. A number of these lawsuits were brought together under the name Brown versus the Board of Education of Topeka, Kansas. The National Association for the Advancement of Colored People supported plaintiffs suing over school segregation. There was a lawyer who worked for the NAACP called Thurgood Marshall, and he eventually became the first African American justice on the Supreme Court. So these cases were combined and brought before the Supreme Court. And a very important fact here is that President Eisenhower had just appointed a new Chief Justice, Earl Warren. Now, Earl Warren surprised Eisenhower by not just writing a majority opinion that struck down the separate but equal doctrine, but also by actually convincing all of the justices to unanimously strike down school segregation in this case, which was handed down in 1954. Their ruling was that separate school facilities are inherently unequal and therefore violate the 14th Amendment to the Constitution. Yet, Brown versus Board was limited in its scope and did not order an immediate desegregation. The implication, however, was that the 14th Amendment was now used as a mechanism for protecting racial minorities. It removed the legal justification for segregating public services. It removed the legal justification for de jure discrimination. With all of that said, de facto segregation remained. Before the 1968 Housing Rights Act, it was very common to have certain neighborhoods off limits to African Americans. And so minority-only neighborhoods produced minority-only schools. So Brown versus the Board of Education was handed down in 1954. It wasn't until 1968 that Congress basically got rid of discrimination in housing. Another problem with Brown versus the Board of Education is that many families feared reprisal for suing school districts to comply. In that time, the Ku Klux Klan, the KKK, was very active in the South. There are actually a couple of movies that depicted this period and the actions of the KKK. One of them is Ghosts of Mississippi, with, I think it was James Woods was the actor. There was another movie called Mississippi Burning, which concerns a federal investigation into lynching, the practice of lynching in the South in the 1960s. And that, I believe, was with Gene Hackman. And they're both pretty good films. I recommend them. So this graph shows the percent of minority students, for our purposes African American students and Latino students, in minority majority schools. Minority majority means that the majority of the students in the school are either black or Latino. So in 1968, you see that almost 80% of African American students, the blue bar there, were in minority majority schools. That statistic has dropped by 1980. By 1980, it's just over 60%. But then if you follow the blue bar, it works its way upwards until by 2009, it's about 85% of African Americans are in minority majority schools. And you see the same trend happening there with Latinos. The reality is, most children will go to the school that is closest to their home. And there is a tendency for African Americans to live among other African Americans and Latinos to live among other Latinos, and for whites and Asians to live among other whites and Asians. That's just a tendency that has sort of always been there, even with the act of Congress that prohibited housing discrimination. In fact, I read somewhere that the city of Chicago, which has always been run by liberal Democrats, is actually the most segregated city in America. There are certain neighborhoods where white people just don't go in Chicago. But that is not due to any governmental policy in particular. Rather, it is more due to history and settlement patterns. So, what were some remedies here? The National Guard was used to protect minority students. There were 2 points in particular in Little Rock, Arkansas, and then also in Alabama. There were instances where the National Guard had to be sent out. There were Justice Department investigations. There was the busing of students across school boundaries. However, that was very controversial and very unpopular. Another tactic used by the civil rights movement in the second half of the 20th century was the boycott. In Montgomery, Alabama, the bus company there had a policy that African Americans could purchase a ticket and ride the bus and sit in a seat, but if a white person got on the bus, a white person or the black person would have to give up their seat to the white person. Rosa Parks was arrested for disorderly conduct for refusal to give up her bus seat. The African Americans of Montgomery boycotted the bus company, meaning that they refused to purchase bus tickets anymore. And they would get to work by what we would today call carpooling, or by walking or riding a bicycle, but they just wouldn't take the bus. Well, it turned out that 50% of this bus company's customers were African Americans. And so this boycott very nearly forced them into bankruptcy, and so they gave up their segregated seating voluntarily without any government coercion. There was no lawsuit involved there. It was very effective. Now, in the 1950s and the 1960s, if you wanted to reach every African American in town, you would go to their church on Sunday. And so black ministers became some of the primary leaders in the civil rights movement. Dr. Martin Luther King Jr. is the most famous. He believed in something called civil disobedience. He wrote a letter from the Birmingham jail outlining his thoughts on civil disobedience, the nonviolent protest of the law. The key there is nonviolence. What they would do is they would not comply with the law, but they would do so in a nonviolent manner. So nonviolent non-compliance with laws that they considered unjust. I'll give you an example. We'll talk about this in a moment. In Alabama, there were a number of restrictions on when African Americans could register to vote, in addition to the literacy tests and so forth. And there was also a law in Alabama that no more than a certain number of African Americans could be assembled in one place in public, and so forth. And so nonviolent noncompliance in their case would mean having more than that number of African Americans assembled out in public, and so forth. So there were several important civil rights acts enacted in the 1960s. I've already talked about the 1968 Housing Rights Act. In 1960, Congress passed a law that established federal inspection of polling places. However, that law was very watered down, the 1960 Act. By contrast, the 1964 Civil Rights Act barred discrimination in employment based on race, color, religion, sex, and national origin. Now, Lyndon Baines Johnson was president at that time, and he had supported the 1964 Civil Rights Act, and he was very proud of it. However, the following year, in March of 1965, Dr. Martin Luther King organized a voting drive march, March 7th of 1965, across the Edmund Pettus Bridge to try to get African Americans registered to vote. I read a statistic somewhere, only something like 3% of eligible African Americans in Hazard County at that time were registered to vote. And so he invited camera crews and he invited the media. And I'm going to show you a brief clip here.
Be detrimental to your safety to continue this march, and I'm saying that this is an unlawful assembly. You are to disperse. You are ordered to disperse, go home, or go to your church. This march will not continue. Troopers here advance toward the group. See that they disperse. a right to walk.
Okay, so these images were transmitted throughout the country, and many white people were horrified by it. It caused a backlash. And so later in 1965, the United States Congress enacted the Voting Rights Act, which banned literacy tests for one, but also established that there were certain areas in the United States with a history of discrimination that would be subject to federal approval of any changes in their voting laws whatsoever, even if it was something as little as closing a polling place. Now, during the Obama administration, during his first term, the Supreme Court ruled in Shelby County versus Holder that coverage formula was obsolete. And so that effectively defanged the Voting Rights Act of 1965. And again, I've already mentioned in 1968, Congress enacted a law that barred housing discrimination. All of these were justified by the Equal Protection Clause of the 14th Amendment. So, in theory, when you go in front of a court, it shouldn't matter if you're white or black. And I guess that can be called legal equality. With regards to material equality, as you can see from this graph, according to the 2010 census, about 10% of white people were living in poverty, but approximately 27% of African Americans were living in poverty. So that's 1 in 10 white people living in poverty versus 1 in 4 black people living in poverty, and there's a similar number there for Hispanics, Latinos. Notice that Asians are closer to whites in terms of poverty rate than they are to African Americans and Latinos. We'll talk about that in a moment. Here's another shocking statistic. 1 in 106 white men over the age of 18 are incarcerated as of the 2010 census. 1 in 36 Hispanic men over the age of 18 were incarcerated, according to the 2010 census. 1 in 15 African American men over the age of 18 were incarcerated. And then if you just narrowly focus on the age group of black men from 20 to 34 years old, 1 in 9 were incarcerated. And it'll be interesting to show what the 2020 census reveals about this. Now, that is effectively saying that if you have a white 21-year-old male and a black 21-year-old male, the black 21-year-old male is 10 times more likely to be incarcerated than the white 21-year-old male. And that is pretty shocking. There are a number of different reasons why the poverty rate is higher for African Americans and why the incarceration rate is higher for African Americans. If you ask 10 different scholars, you'll get 11 different answers. You could ask someone with a PhD in criminal justice that question and get one answer, and then ask someone with a PhD in history that question and get a totally different answer. And likewise with sociologists and economists and political scientists. Since this is a political science class, let's take a look at the number of black elected officials. In 1964, there were 5 members of Congress who were African American. In 1970, there were 9 members of Congress that were African American. In 1980, there were 19 members of Congress that were African American, the same with 1990. But then by 2008, there were 42 members of Congress that were African American. Keep in mind there were 535 total members of Congress, not including the non-voting representatives from Puerto Rico and Guam and Washington, D.C. And so it's approaching 10%, slowly but surely. Another interesting statistic to look at is life expectancy. In 1935, white people had a life expectancy of 62.9 years, but for African Americans, that number was only 53.1. That's a difference in life expectancy of 9.8 years. If we go to the 2010 data, we find that whites now have a life expectancy of 79 years, and African Americans have a life expectancy of 75.1 years. So the difference in life expectancy has dropped to under 4 years. It's gone from almost 10 years to under 4 years. So that is progress. And I think most people would agree that there's been progress since the 1960s. Affirmative action refers to direct, positive steps to recruit minorities. At one point, that even included quotas. Now, affirmative action policies became popular in the 70s and lasted through to the 90s. However, they produced a massive backlash. In 1978 and again in 1995, the Supreme Court of the United States rejected quotas, particularly in the hiring process. A quota is a minimum number that must be met. Quotas are illegal, but goals are legal. It is legal for an employer to have a goal of maintaining a diverse workforce, but they cannot use race and ethnicity and gender as either a positive or negative factor in the hiring process. So, Western states like Wyoming were the first to grant women the right to vote. Why do you suppose that is? Well, Wyoming in the late 1800s was mostly settled by men. And so Wyoming did become the first state to give women the right to vote. And part of their reasoning to do so was to try to attract more women to the state. So let's talk about women's suffrage. Suffrage refers to the right to vote. In the 1800s, most states had the law of coverture. Women's rights operated through a male guardian, their husband, their father, even an adult son. So what does that mean? In some places, a woman could not give testimony in court. A woman could not sign a legal document. She would have to have her husband or her father or her son sign it for her. One example, after Abraham Lincoln was assassinated, his eldest surviving son, Robert Todd Lincoln, effectively became Mary Todd Lincoln's legal guardian. Even though she was an adult, female, because she was a female, her rights operated through a male guardian. And with her husband dead, her male guardian became her oldest son, Robert Todd Lincoln, who later had her committed to an insane asylum. In 1848, the Seneca Falls Convention took place, and this is often cited as the beginning of a national women's suffrage movement. Demonstrators met with abuse. They were heckled, they were catcalled, they had things thrown at them, and so forth. They were also arrested many times for trespassing or disorderly conduct. However, by 1916, women had full suffrage in 15 states and at least partial suffrage in 23 states. In 1920, the 19th Amendment was ratified by the states, which guarantees the right to vote for women. It says that the right to vote cannot be denied on account of gender. The 1964 Civil Rights Act barred discrimination based on gender. In 1972, there was an attempt to ratify an Equal Rights Amendment, but the states failed to ratify it. Despite that, by the 1990s, the number of women in Congress increased. In fact, one of the people who served on my master's thesis committee was Professor Barbara Burrell, and she published a book called A Woman's Place is in the House. And the title of that book is ironic. She was looking at Congress, and what she found was that controlling for all factors suggested by the literature, a woman was actually more likely to win an open house seat than a man. So when you control for the amount of campaign spending and all of these other factors, what she found was that when an incumbent member of Congress gave up his or her seat, a woman was more likely to win the contest for that seat than a man was. But still, Congress remains dominated by men for the simple reason that more men are running for Congress than there are women running for Congress. Sexual harassment is discrimination in school or workplace based on sex. It's very important to keep that in mind. Sexual harassment is a form of discrimination. There are two types. There's preferential treatment or quid pro quo sexual harassment, where somebody who has some sort of authority grants a bonus, a promotion, or a good grade in exchange for sexual favors. There's also hostile environment sexual harassment. This is lewdness and unwanted sexual advances. And by lewdness, I mean more than, like one little joke. Moving on, Hispanics and Latinos mobilized in a similar manner as African Americans. The League of United Latin American Citizens and the United Farm Workers are two of the major organizations which have worked for equality for Latinos. 60% of Latinos were born in the United States of America. Yet, in the undocumented immigrant population, Latinos make up roughly 3/4. Now, I want to note both the Census Bureau and the Equal Employment Opportunity Commission use the terms Hispanic and Latino interchangeably, and so do I. The term Asian American is a very difficult term. The people of Asia are simply too diverse to make generalizations about. There's East Asia, which includes China and Korea and Japan, and that area is very distinct from South Asia, which includes India and Pakistan and Bangladesh. And so we can talk about some particular groups. For example, the Chinese began moving to this country in the late 1800s to build the railroads. From 1882 to 1965, the United States would only allow a certain number of Chinese people into the United States. Japanese people have been coming to the United States for over a century, particularly in Hawaii and the West Coast. After Pearl Harbor, President Franklin Delano Roosevelt signed an executive order mandating that all Japanese Americans living on the West Coast had to register. And later, he mandated that they were moved to camps on the eastern side of the Rocky Mountains, like in Nebraska and so forth. Congress did not object, and the Supreme Court of the United States initially upheld this executive order as a wartime necessity. Later on, however, the Supreme Court mandated that there had to be a timetable for returning these people to their homes after it began to look like Japan was going to lose the war. Asian Americans were once called the model minority. However, that term is very unpopular now. The fact of the matter is, a person who is born in China and moves to the United States is more likely to start a business than a person who was born in the United States. Asian Americans are also more likely to graduate college than African Americans and Latinos. Yet they have had difficulty ascending to the upper echelons in business and politics. For example, a few years ago, there was a survey done of law firms in the United States, and what they found was that Asian Americans made up approximately 10% of all of the lawyers in private practice, but only about 1% of partners at these law firms. So in the United States, a partner is basically an owner of the firm. Native Americans or indigenous Americans suffered from Indian removal policies and military attacks. Their current status is domestic dependent nations. So they are U.S. citizens, but on their reservations they have sovereignty. On their reservations, they only answer really to the federal government. Now, I want to point out that there is no federal law that prohibits casino gambling. All of the laws concerning casino gambling are state laws. And so in the 1970s and the 1980s, many Indian tribes opened up casinos on their reservations, even in states where casino gambling was illegal, like Wisconsin and Iowa. However, this was allowed because they are only subject to federal laws, not state laws. So, is the United States a mixing pot? That is an analogy or a metaphor that used to be used to describe the United States as a place where people from different races and different ethnicities came together and sort of mixed together. So you have white people going to Taco Bell and going to Chinese restaurants and so forth. However, there have been movements sort of rejecting this idea of becoming American. For example, in the 1960s, there was the Black Power movement, which emphasized black institutions and interests. Some people who believed in black power would only shop at stores that were owned by African Americans. In California, there's a Chicano tradition, a defiant pride in Latin culture, resistance to the use of English. Is there a national culture of the United States? It's difficult to say. I remember when I was growing up, there was a TV show called Baywatch that I think people sort of associated with being sort of emblematic of American culture. It was certainly popular overseas, especially Germany. So, the 1964 Civil Rights Act prohibits discrimination based on race, gender, religion, or national origin. What groups were unprotected by the 1964 Act? Well, the first one that comes to mind is the LGBT community. I'm going to talk about same-sex marriage. The right to get married can be considered part of the full life of the community. In the 1970s, there were some attempts by same-sex couples to wed, but they typically did not survive court challenges. In 1996, President Bill Clinton signed the Defense of Marriage Act, which defined marriage as being between one man and one woman. In 2013, parts of the Defense of Marriage Act were struck down, and so a handful of states started issuing marriage certificates to same-sex couples. Now, what would happen is that same-sex couples would, for example, a same-sex couple living in Alabama might go up to, say, Vermont to get married, and then return to Alabama, and they would have an expectation that they would get the same rights as married couples. So that includes the right to file taxes jointly and to name one another as next of kin. And so the refusal by some states to grant those rights and those privileges to same-sex married couples led to a subsequent Supreme Court ruling in 2015 that mandated that same-sex couples should be accorded the same rights, and that any governmental agency which issues a marriage certificate must issue them to same-sex couples as well as heterosexual couples. Now, I don't mean to pick on Alabama, but after this Supreme Court ruling, there were some counties in Alabama that refused to give out any marriage certificates at all to either heterosexual couples or same-sex couples. And there's an old expression, cutting off your nose to spite your face. So, there were some parts of the country where they were so against same-sex marriage that they refused any marriage certificates whatsoever, even to heterosexual couples. Again, there has been progress in the struggle for civil rights and the right to participate in the full life of the community. And I think anyone could agree to that. If you pick up a history book, you can see we are a more inclusive society now than we were 60 or 70 years ago.